Hello, good day all. Today I am starting Family Law 2 for only regarding exam oriented discussion. This presentation is only to those persons who are going to write exams. I am going to cover only the exam oriented topics which are given as essay and case laws. The topics discussed in this are Hindu joint family, coparcenary, Mithakshara and Dayabhaga coparcenary, changes due to legislature, changes brought about by amending of Hindu Succession Act 1956 to 2005, Karta, doctrine of PO's obligation, partition of joint family property, Hindu Succession Act. I have mentioned how they are important in the brackets. Coming to Hindu joint family. Hindu joint family has its origin in ancient texts and writings of Smritikars. It is described as earliest unit of human society. Hindu joint family best defined by stating the jointness of members of whom it is made up. It consists of all persons lineally descended from a common ancestor and includes their wives and unmarried daughters. A daughter after marriage becomes a member of husband's family. Existence of joint estate is not essential for a joint family. The fundamental principle of jointness is subindaship as observed by the Supreme Court. The Hindu joint family was undivided family is an institution sui generis. It is mostly governed by Hindu religion Hindu religion and customary practices. Coparcenary. Coparcenary is a narrower body than a joint family. They are the owners of the joint family property. It includes only those who acquire by birth an interest in the joint or as it is called coparcenary property. These being sons, grandsons, great-grandsons of the holder of the joint property. Only male members can be copartners. Female members has no right to enforce the partition. The female members may be allotted shares if the partition takes place, but should not ask for partition. Every copartner has a right of maintenance out of joint family property. Mithakshara coparcenary system. The formation of Mithakshara coparcenary is a single person cannot form a coparcenary. There should be at least two male members to constitute it. Like a Hindu joint family, the presence of senior-most male member is a must to start a coparcenary. A minimum number of two members are required to start and to continue a coparcenary. Moreover, the relation of father and son is essential for starting a coparcenary. For example, a Hindu male obtains a share at the time of partition from his father and then gets married. Till the son is born, he is the sole male in the family, but he alone will not form a coparcenary. On the birth of his son, a coparcenary comprising of him and his son will come into existence. When this son gets married and a son is born to him, the coparcenary will comprise of father, his son, and his grandson SS. When a coparcenary is started, the senior-most male member with his son, that is lineal male descendant, till four generations, inclusive of him, of male line, will form a coparcenary. As a minimum of two male members are required to form a coparcenary, a sole surviving coparcenary cannot form a coparcenary by all by him. Coparcenary is limited. The coparcenary is limited to three generations of lineal male descendants of last holder of the property owner. According to the tenets of Hinduism, only descendants up to three generations can offer spiritual ministrations to the common ancestor. Besides, only males can be copartner because the females invariably leave the father house and assume domestic duties as they enter in the husband's home. Dayabhagha Coparcenary. It is based on Yajnavalkya Smriti, which is interpreted by Jimutavahana. This school of thought is applicable only in West Bengal and Assam. In Dayabhaga school, both male and female are copartners in their father's property. In Dayabhaga school, copartnership share is fixed. In this school, both daughters, whether married or unmarried, and sons have equal right. In this case, if A is alive, B and C do not have the right to property. If A dies, then only the coparcenary starts between B and C. In this case, if A and B dies, then all property belongs to C. Joint tenancy in English law. Joint tenancy refers to a situation wherein two people split in the ownership of property but by putting both of their names on the title. This means that half of the property's value belongs to each person. Should one of those people die, if one of those people die, then the other person takes claim to 100% ownership over that piece of property. This is called the right of survivorship. Many states actually consider married couple to be joint tenants, even if both of their names are not on the deed. Changes brought in the Mithakshara by legislature. Since co-partnership property has not been defined under the Hindu Succession Act, courts have continued to attribute the same understanding as Mithakshara. Co-partnership property means, and it yet includes ancestral property, acquisitions by co-partners with the help of ancestral property, separate property of co-partners thrown into the common stock, and joint acquisition by co-partners. Coming to amendment in 2005 regarding the co-partner. The daughter of co-partner shall by birth becomes co-partner in the same manner as son, have same rights in the co-partner property, be subjected to same liabilities in respect of the same co-partner property as that of a son, and any reference made in respect of the co-partner son shall be deemed to include to daughter also. It means in the amendment, daughter is added as a co-partner. Hindu Succession Act 1856 is the old one, and there are many changes done in 2005. They are the daughter is made as a co-partner by birth in the same manner as that of a son. She has same rights as son in the co-partnership. Her liabilities in Mithakshara co-partnership are as son. The daughter and other females are now not only co-partners, but they are also entitled to bequeath, right to have their share in the co-partnership like their male counterparts. Where a Hindu male dies after the commencement of a Hindu Succession Act 2005, his interest in the property of Hindu joint family governed by Mithakshara law shall devolve by testamentary or intestate succession as the case may be, but not by survivorship. Co-partnership property shall be deemed to have been divided as if partition has taken place and the daughter has got the same share as that of a son. By the new act, in the list of heirs of class 1, the following heirs have been added. Son of a predeceased daughter, that is daughter's son, daughter's daughter, daughter's son's daughter's daughter. Due to change in Act 2005, affected PO's obligation of a son's son to pay the debt of fathers, grandfathers, grandfathers, the debt contracted before the day 20th December 2005 shall not be governed by the present law. The separate property of father, grandfather, great-grandfather would be liable and the share of the fathers would be liable, but co-partner share would not be liable. Coming to Karta, it is better to read under the following headings: Introduction, Position, Duties and Liabilities of Karta and Powers of Karta. Karta. Karta is the head of the Hindu joint family. He is also known as a manager. Senior-most member of the family or father of a family acts as a Karta. Even the junior can become Karta if the other male member agrees to it. A minor male may also act as a Karta through his legal guardian till he becomes major. Women as co-partner of or Karta. In the case Gangoji Rao versus Chennappa, the father died and left his wife and two minor sons. Wife alienated property, sons challenged the mother, position as Karta. The mother contended that it was made out of necessity. Supreme Court held that, quoting the previous verdict in case of Commissioner IT versus GSM Mills, held that woman cannot be a co-partner and Karta. Position of Karta. Karta acts as a head on behalf of Hindu joint family. Position is sui generis. It means his managership is not like that like that in commercial firm or relationship, and relationship is not like that of a principal and agent or firm and partner. It emerges by itself. Karta, duties and liabilities of Karta. He is responsible to maintain all members of the family. If fails to do so, members can sue him and recover the arrears of maintenance. He is responsible to perform the marriages of all unmarried persons in the family. He has to prepare the accounts if suit filed by the members of the family. He is bound to pay taxes and all other dues on behalf of Hindu joint family. He may be sued for failure to discharge the duties. Powers of Karta. The powers are not larger than a co-partner, nor the Karta has no larger powers than a co-partner. He does not get any remuneration for services he do as Karta of the family. The powers are categorized into alienation powers, that is, for the purpose of legal necessity, benefit of estate, and for the performance of indispensable religious duties. Other powers. Purpose of legal necessity. This is a big slide with much information, as it is very important for the exam. I have mentioned everything. The Karta can alienate the joint family property for the purposes of a legal necessity. The following had been held to be a legal necessity: payment of government revenue and debts payable out of family property, maintenance of family members, marriage expenses of family, especially daughters, performance of religious ceremonies of family, expenses of necessary litigation, costs of defending the family against criminal charges, payment of debts incurred for family business, expenses for augmenting the means of livelihood of members of family, cost of building a residential house for the family, and expenses for repairing the house, sale of female property with the object of conveniently adjusting the shares of rest of family. For the benefit of the estate, the Privy Council has elaborately illustrated as to what are the incidents of benefit of estate in Palaniyappa versus Devski Muni. The Karta has an implied authority to do whatever is best for all concerned, and such transactions are justifiable on principle of benefit to the estate. The benefit to estate includes protection of estate from extinction, deterioration, litigation, etc. An alienation made by Karta for benefit to the estate is justified. The performance of religious duties of joint family. Karta can alienate the property for the purpose of religious duties like Shraddha, that is, offering pindas and udakas to manes of ancestors. Karta may make a gift of family property to a reasonable extent. Ramalinga versus Siva Chidambara. Here, the compulsory immovable property was made as gift to a temple on occasion of father's funeral, that is, pious purpose, was considered as valid. Ammattai versus Kumareshan. Here, the gift made by father to his daughter for her maintenance from joint family property was held valid. Other powers are like powers over income and expenditure, or to manage joint family business, contract debts for family purpose, refer to arbitration, power of compromise, power to give discharge, power to acknowledge debts, power to represent in suits, power of alienation of joint family property. Coming to case scenario, Fatimunissa versus T.R. Gapalacharya. This case explains regarding the Karta's interest in representing joint family property. In this case, court held that Hindu widow inheriting his husband's share does not by itself disrupt the joint family status. After such inheritance, she continues to be a member of joint family and Karta can represent her in all suits. The enlargement of her limited estate into full estate by virtue of Section 14 of Hindu Succession Act does not bring about change in Karta's power to represent joint family, joint to represent as joint member including her. Doctrine of Pious obligation is very important. Short notes, essay, or a case. Pious means godly, devout, religious. Pious obligations means duty of Hindu due to deep devotion to religion. As per Hindu scripture, it is the duty of son to pay off or discharge his father's debts. The religious obligation is attached to the son as well as grandsons and to the great grandsons also on ground that they are all attached as co-partners to each other by their birth. The putra, by repaying or clearing debts, discharges his parted father or ancestor from indebtedness and enables him reach heaven. This duty or obligation of sons rests on a special doctrine called doctrine of pious obligation. However, these debts extend to non-avyavaharika debts only. This debts extends to non-avyavaharika debts only. Avyavaharika debts means those are illegal or immoral debts like gambling, races, etc. Anthony versus Chinnasamy. In this, the Supreme Court held that the doctrine of pure obligation is not just a religion obligation but has passed in the realm of law. The liability of son is not a gratuitous obligation to pay father's debts but a salutary counterbalance to the principle that the son from the time of birth acquires an interest in the joint family property. The doctrine is in consonance with justice, equity, and good conscience. What are the changes in new doctrine and what are there in the old doctrine? In old doctrine, the debts are cleared after death of the father. Son has to pay principal with interest. Grandson has to pay principal amount only. The great grandson has no obligation unless he gets ancestor property. Coming the new doctrine, the obligation arises even during the lifetime of father. All sons, son are liable to pay debts with interest. Debts outside the scope of doctrine are commercial debts. It is included in new doctrine. Suretyship debts. It is binding to son even in new doctrine. Gaming debts. They are outside doctrine in both laws. Avyavaharka debts. It is outside the doctrine. Coming to next question, partition. Partition is a process by which the joint status is put to an end. It is the division of joint family, both property and status. There are members of the joint family who can ask for partition and are entitled to a share also. There is another category of the members of a joint family who have no right to partition, but if the partition takes place, they are entitled to share. The persons who are entitled to demand the partition are the partition of the joint Hindu family may take place at the instance of the following persons, sons and grandsons. Under the Mitakshara law, the right of a son, a grandson, and a great grandson, as well as every other adult member of a co-partnership, can demand a partition even against the consent of the others. The authority of Supreme Court in Puttarangama versus Rangama held that a suit for partition and separate possession of ancestral joint family property of one of the partners is maintainable even if the father is joined with his brother and is not willing and does not consent to such partition. After-born sons. After-born sons can be classified under two heads. Firstly, those born as well as begotten after the partition. Secondly, those born after partition but begotten before it. A son in her mother womb is treated in the law of existence, in the law in existence, and is entitled to reopen the partition to receive a share equal to that of his brothers. In the case of a son born as well as begotten after partition, if his father has taken a share for himself and separated from other sons, then after born son is entitled to his father's share at the partition and also his separate property to the exclusion of separated sons and is not entitled to open the partition. Illegitimate sons. An illegitimate son among the three upper classes does not have any vested interest in the property and therefore cannot demand a partition, although he is entitled to maintenance out of his father's estate. The Madras and Allahabad High Courts have held that an illegitimate son of a Sudra may enforce a partition against his illegitimate brothers, but not against his father or his father's co-partners. The Bombay High Court has also taken the same view, but the Calcutta High Court had taken an opposite view. The share of an illegitimate son is half of what he would have got had he been a legitimate son, and according to others, his share is half of that of a legitimate son. Widows. A widow, though not a co-partner under Mitakshara law, could still claim a partition of the joint estate under the Hindu Women's Right of Property Act 1937. Mere partition of the estate between two widows does not destroy the right of survivorship of each to the properties allowed to the other. Adopted son. An adopted son, like a natural born son, would be entitled to demand a partition any time after adoption. But where a son has been adopted by the parents and a natural son is begotten subsequently, although the adopted son was to be treated at par with the wife and natural son. Hindu Adoption and Maintenance Act 1957 56 has done away with the discrimination and enabled the adopted son to get a share equal to that of a natural son on partition. Minor copartner. A minor copartner is also entitled to affect a partition in case of joint status does not remain beneficial to his interest. He cannot file the suit himself, but any other person on his behalf can file such suit. His minority or the minority of other members of the family would not be a hindrance to affect a partition by him. If the partition has already taken effect detrimental to his interest, he could challenge it on attaining the majority. Alienee. An alienee of a person's interest, if such an alienation is valid, has a right to demand partition. In Srimati Kailashpati Rao Devi versus Srimati Bhuvaneshwari Devi, the Supreme Court held that the purchaser of joint family property from a member of a joint Hindu family may have the right to file a general suit for partition against the members of the joint family, and that may be the proper remedy for him to adopt to effectuate his purchase. An execution purchaser of a member's interest and purchaser of the same for value in Bombay and Madras is entitled to demand partition in the rights of that member. Female sharers. The term female sharers include three types of females, namely wife, widowed mother, paternal grandmother. These female sharers cannot demand a partition, but however entitled to get their share when the joint family property is actually divided on partition. Where a suit for partition filed by the co-partner has been withdrawn, the female sharer will not be entitled to continue the suit or to press a demand of his share. If the suit has been dismissed for any other reason, the mother would not be entitled to demand partition in the property. The mother and grandmother would be entitled to get a share on partition only when the partition is effected between the sons and grandsons. Reside and partition of family house by the female. Section 23 of Principal Act has been omitted by Hindu Succession Amendment Act. Now the daughters have the same right as sons to reside and to claim for partition of a parental dwelling house. Allotments of shares or rules of shares. This is a separate question where you will get the one case law. Fathers and sons. If partition made between father and two sons, each gets equal share, that is one third share. Among brothers, each takes equal share to the other. This concept Jyeshtha Bhaga is obsolete now. Father died, then the property must be divided equally among his brothers and their mother. If alive, death of a co-partner, his right to share passed to his wife, that is widowed, and his male issues, provided each issue is within the limits of the co-partner, that is up to 3 generations only. Per stripe rule. If partition is made among branches, property is divided equally among the branches. Female share. The females who take the share on partition are wife, equal share of that of children; widowed mother, equal share of that of as that of sons; widowed grandmother, share only if partition is among grandchildren, her own children being dead, or between collaterals such as between uncle and nephew. Daughter, as amended in 2005, can demand partition equally with that of a son. Effects of partition. The partition may take place in following way: by filing a suit, by agreement among co-partners, by arbitration. Consequences of partition are: co-partnership is dissolved, members share members share becomes separate property. On his death, his property devolves upon his heirs. Case laws in succession of property. Question patterns what we get here are: P died leaving behind his wife, two sons, and one daughter. He, along with his two brothers, constituted Hindu joint family. What will happen to his undivided interest in the joint family? This is discussed under Hindu Succession Act 1956 to 2005. The rest we will discuss when we discuss in Muslim law of inheritance and Christian law of inheritance. Coming to case law, pattern to write in exam. Issues are: male died intestate, distribution of shares according to Hindu Succession Act 1956. Explanation. Section 8 of Hindu Succession Act gives how to divide the partition. Shares. How to divide the shares. Defining class 1, class 2, agnate, cognate, and doctrine of escheat. The application in this case and other illustrations. Conclusion. Writing regarding the division of shares. How much to whom the shares are divided. Dying intestate. This would apply where the male Hindu dies intestate, not having made any will or having made an invalid will. Property. Here means the self-acquiring property and also the co-partner property after the partition. The application of act. It applies when there must be a death of the male. The male must be Hindu and he has left behind some property and he has not made any valid will in regard to his property, and the male died after commencement of the act. Hindu male intestate, that is died without will and its succession of property. This is discussed under section 8 to 13 of the Hindu Succession Act 1956. According to section 8, when a male dies intestate, his property devolves as follows. Firstly, upon heirs specified in class 1 of the schedule. If no class 1 heirs, property devolves upon class 2 heirs. In the absence of above two classes, the property devolves on agnates. If there are no agnates, then property devolves on cognates of the deceased. In the absence of all the above, property goes to the government by escheat. Coming to class 1 heirs. Who are class 1 heirs? Son, daughter, widow, mother, son of predeceased son or daughter, daughter of predeceased son or daughter, son or daughter of a predeceased son of a predeceased son, widow of predeceased son, widow of predeceased son of predeceased son. In 2005, some other relations are also added in class 1 heirs. They are son or daughter of a predeceased daughter of a predeceased daughter, daughter of a predeceased son of a predeceased daughter, daughter of a predeceased daughter of a predeceased son. Shares of class 1 heirs are dealt in section 10. Rule 1. Intestate widow or all widows together shall take one share. Rule 2 is surviving sons, daughters, mothers of intestate shall take each one share. The rule 3 is the heirs in the branch of each predeceased son or each predeceased daughter of intestate shall take one share between them. Rule 4 is among heirs in the branch of predeceased son shall be so made such that a widow, surviving son and daughter gets equal share. In the branch of a predeceased daughter, shares shall be made that surviving sons and daughters get equal shares. Class 2 heirs. Heirs are divided into 9 groups. Each group is mentioned in separate entry in the schedule. According to section 9, the heirs of first entry are preferred to second entry and so on. Section 11 discusses lays down the mode of distribution of property among class 2 heirs. The property shall be divided between every two class heirs in equal shares. Agnates and cognates. Agnate is a person said to be agnate when he is related to the deceased wholly through the male link or relation by blood or by adoption. Son's son, brother's son's son, father's brother's son. Those agnates who come under class 1 and class 2 heirs do not come under agnates category of section 8 of the act. Cognates. A person said to be cognate if he or she is related to the deceased wholly through the female link either by blood or by adoption, that is daughter's son, sister's daughter. Those come under class 1 and 2 do not come under cognates. P died. Coming to the case, P died leaving behind his wife, 2 sons and 1 daughter. He, along with his 2 brothers, constituted Hindu joint family. What will happen to his undivided interest in the joint family property? This is discussed under Hindu Succession Act 1956 and amended on in 2005. So the conclusion is P plus 2 brothers form a Hindu joint family. The share should be first between them. Therefore, each gets 1/3 share. So the P left wife, 2 sons and 1 daughter. So they are class 1 heirs. So they should get equal shares. That is 1/3 by 4. That is 1 wife, 2 sons and 1 daughter. So 1/3 by 1/4. That is 1/12 of 1/12 share that each will get. Thank you.